My name is Ian Levengood, on behalf of my client Nathan Wood, the appellant, and co-counsel Philip Piazza. We are here seeking reversal of the trial court's order, wherein it awarded Portfolio Recovery Associates, the non-prevailing party at the trial court level below, appellate attorney's fees of over $27,000 for its efforts focused exclusively on overturning Wood's prevailing party remedy. Wood believes the trial court erred.
So, sorry to interrupt. Do you wish to reserve any time?
5 minutes, Your Honor.
You got it.
Thank you, Your Honor. I appreciate the reminder.
Yes, sir.
Wood believes that the trial court erred for two reasons. One, PRA's appellate attorney's fees efforts were exclusively outside the scope of the services that were compensable under the card member agreement that governed the relationship between the parties. And two, PRA failed to satisfy the threshold requirement and element of being the prevailing party at the trial court level below. And for those reasons, we think that the order should be reversed.
Can you address first our jurisdiction to review the entitlement issue where the circuit court in its appellate capacity determined entitlement and remanded it to the trial court for this issue of whether the attorneys were salaried or not?
Sure. So are you asking for the scope of review, de novo versus?
Yeah, because I think you're arguing that the trial court misinterpreted the circuit court's order.
Yes, Your Honor.
And
So,
direction.
yes, Your Honor. I do believe that this is a de novo review for several reasons, because these are legal issues that are being presented to the court. These aren't factual determinations. So I do think it's a de novo review to begin with, and not to be addressed as an abuse of discretion. These are legal questions that are being asked as far as whether or not the trial court had the authority to address the scope of the contractual provision.
Right, and that's what I'm asking you to address.
It's a legal question, yes, Your Honor. So, the scope, I mean, the case law is decently clear that a contractual provision wherein someone's applying for fees under that contract, and that is the only basis for awarding.
No, I think what I'm asking is the circuit court determined entitlement.
Yes, Your Honor.
Okay, and so how can if the trial court's sole determination from the remand order was, I think it said the court will grant the rehearing only to amend the original order granting appellate fees in order to direct the county court to determine whether appellant's counsel is salaried. And only if counsel is not salaried should the county court undertake to determine the amount. Sure.
So
Okay.
amount has to be weighed by the trial court. There was no evidence at the circuit court level, at the intermediate appellate court level. And so that judge had no ability to be able to evaluate what efforts were expended by appellee's counsel in reversing the remedy that my prevailing party had below. And so making that determination, looking just at the collection cost provision of the card member agreement is a determination that because they had prevailed at the appellate court level, there was an entitlement to fees. Now, entitlement to fees, you still have to go then look at what efforts were expended by the attorneys in their efforts in the appeal, and focus on what those efforts are.
So you're not arguing that we are not bound by the circuit court's determination of entitlement?
There's an entitlement to fees, yes, Your Honor. I mean, that's been worked, so we're not challenging that, but entitlement.
So you're saying we can't revisit that? Or you're not arguing that we can revisit it, to put it differently?
No, you could revisit it. We're not making the argument that entitlement was necessarily incorrect in the vacuum at that time in the appellate court. The judges at the appellate court had the provision of reading the collection cost provision of the card member agreement. That is all they had. There was absolutely no evidence before the court. There's no testimony, there's no time records, nothing was attached to their motion for appellate attorney's fees. And so in a vacuum, the circuit court judge awarded by looking at the collection cost provision that they were entitled to fees.
But your argument now is that it was outside the scope of what's permitted by the contractual provision.
Once looking at the evidence, yes, Your Honor. So the first time it was remanded down for the evidentiary hearing, the first time evidence was considered on this issue at the trial court level. That is where testimony was provided by one of the attorneys for PRA, the appellee. That's also the first time the time records were advanced. And so the yardstick for determining what is compensable under the card member agreement, the collection cost card member agreement, one must look at the efforts to determine what were expended to figure out whether or not they were compensable. We have cited a case, again, it's a Florida Second DCA case, it's the trial practices beyond closure and parts case that
But
talks
aren't
about.
you, I mean, you're really attacking the underlying entitlement issue, because that is what the provision, the circuit court granted fees on.
I guess I would disagree with that characterization, Your Honor. If in hindsight, looking back at the time records that were submitted to the trial court level, let's say for hypothetical purposes, 10 hours were submitted, 5 of the hours were spent when looking at the time
So are you
records.
saying they weren't spent in prosecuting the appeal and prevailing ultimately on the vacating of the judgment?
They weren't executed in collecting the debt.
No. Answer my question though. Are you saying none of them were expended prosecuting and prevailing on the appeal?
All of the efforts of the attorneys for PRA at the appellate level were spent focusing on 3 things, and this was elicited by the testimony of the attorney Jason Lambert. One was arguing whether or not South Dakota law applied in determining the attorney's fee issue. Okay, so it's a choice of law provision, public policy around it, and what
Okay.
would apply. 2, whether or not attorney's fees should have also been awarded under Florida Rule of Civil Procedure 1.420, attorney's fees taxable as a cost.
Litigating entitlement.
Yes, and focusing again on those issues. None of those efforts were focused on collecting the debt. The case was not referred to Nelson Mullins and now Dinsmore, the attorney that represented PRA at the appellate level. None of their efforts, 0 of their efforts were spent collecting the debt. The contract between the parties only provides for attorney's fees to the extent that the file is referred to an attorney for the collection of the debt. None of the efforts were spent collecting the debt. So to finish the hypothetical, had Nelson Mullins come in earlier, had Nelson Mullins' time records and testimony shown that 5 hours of the 10, this is a hypothetical number, obviously, 5 of the hours were spent collecting the debt, 5 of the hours were spent on appellate issues, choice of law, whether or not a multiplier should have been available to my client Wood as the prevailing party below. Then for the first time at the trial court level on remand, evaluating the evidence, the testimony, the time records, one could look at it and say, okay, now looking at the yardstick, looking at the scope of the collection cost agreement that is in the card agreement, so it is the only basis where fees can be awarded to PRA or to Wood in this case, because again, American rule, it's got to focus on the actual language of the card member agreement. 5 of those hours, Your Honor, would have been spent on collecting the debt. Testimony that's there, time records are there. The first time at remand below, our position would have been
okay.
some of it is compensable.
But the agreement, let's look at the language though. It doesn't talk about, I mean, it basically says, to the extent permitted by law, you are liable to us for our legal cost if we refer collection of your account to a lawyer. So they've referred it to a lawyer, they've got legal costs, they prevail on the award of fees that was entered in favor of Mr. Wood here. And so in the broad sense of this language, you're saying that those costs that they spent in litigating and prevailing on the entitlement issue, that they don't fall within the scope of this.
Correct, Your Honor, they are not collection costs. Testimony of Mr. Lambert and the time records, both.
This is legal cost. I mean, I agree the heading says collection costs, but the actual terms say legal costs.
So if I may expound upon that a little bit, I think there's a second part that will further expound upon the fact that these costs are not compensable. Looking at the sentence, Your Honor, just remember, you are liable to us for our legal costs if we refer collection of your account to a lawyer who's not our salary employee. Looking at that sentence, they're talking about referring a case to a non-salary lawyer for collection. It's under collection costs and it says the collection of your account. The next sentence, these costs are referring to the costs incurred, the legal costs that are incurred for collecting the account. So both under the title of this contractual provision, collection costs, in the context of both of those sentences taken together, they're not talking about any fees that could ever be awarded for any issue under the sun. They're talking about if we refer this case to collection, then those efforts, the collection efforts of the attorney, are compensable. I mean, if that's not the interpretation of the plain words of the contractual provision, this is essentially granting people.
Okay, then let me ask you this. Did your client seek fees under the same provision?
Yes, Your Honor.
Okay, and tell me how your client was able to seek fees when it did not pursue collection costs.
Florida statute, section 57Y.
under Florida's law.
Right, that Florida statute has.
Which turned out to be a kind of a discursion because we shouldn't have been looking at Florida law at all, is basically kind of where this landed.
Well, the judge reversed it under South Dakota law. Again, so they focused on South Dakota law. South Dakota law does not have a 57105 sub-7 at large. Okay, but so why it was awarded to us was not just based upon the plain language. So in other words, Wood at the trial court level, when he was originally awarded those attorney's fees and costs, it was not just based upon the four corners of the parameters of the collection cost provision. You bootstrap 57105 sub-7 that basically says, and I'm paraphrasing, that if any action is brought with respect to the contract, then that's unilateral fee provision, otherwise becomes reciprocal. That's a case that, again, PRA is very familiar with. The Florida State Supreme Court has just entertained that under the PRA. And so, that is why Wood was entitled to fees originally under Florida law 57105. And importantly, and Your Honor brings up, that 57105 in Florida law may have been, incorrectly followed. This case was amended. South Dakota law was proffered and purportedly proven, and so that is why the appellate court reversed. South Dakota law, interestingly, though, we cited this in our answer brief, requires at the appellate court level a verified statement of the time records and the fees that are sought. That was not followed here, and so South Dakota law, I think that would be one deficiency why they should not be entitled to the fees as well, is because it's procedure not followed.
Did I read correctly that under South Dakota law, these kinds of consumer credit card agreements are supposed to be construed against the drafter?
Sure, yes, Your Honor, and that's consistent both under South Dakota law and Florida law. Again, it's really the maxim of contract interpretation or drafting. I mean, a contract is to be interpreted against the drafter. A contract's deletion should be strictly construed. We have cited both Florida law and South Dakota law to stand for that proposition. So this collection cost provision, again, undisputedly drafted by Citibank and now owned and used by Portfolio Recovery. Again, it is certainly not clear at best, as we just discussed with Your Honor, and to the extent that the argument can easily be made that this is referring to collection costs. This isn't a failure to collect cost heading. I mean, in other words, this isn't kind of what I would term the absurd result of you can refer this case out, and regardless of the merits of the case, regardless of the efforts of counsel, regardless of the results of the case, the plaintiff could lose the case, the defendant prevails, but at the end of the day, regardless of the merits of the underlying decision, because it was just referred to an attorney for collection, the prevailing defendant now owes attorney's fees that are many, many multiples of the amount of the debt that was originally collected. And to be sure, that is the fact pattern before this course here today. Mr. Wood undisputedly prevailed on the case, 100-0. That was not appealed by PRA. Remedy was provided by the trial court judge, granting him attorney's fees and an attorney fee multiplier based upon the results of the case. And that remedy was the only thing challenged. That remedy was the only thing that was reversed. Okay, that is it. There was no opportunity at the appellate court level to weigh the merits of what that fee should be, because there was no evidence for the circuit court. There was no evidence for counsel for Wood to try and push back on. A, it wasn't there. B, according to South Dakota law, it should have been there. And the propriety of perhaps why South Dakota has that is it because it would avoid the very situation.
Was that raised in the rehearing?
Yes, yeah. So
The proffer of the I guess evidence of the amounts.
Well, I mean, most of the rehearing focused on, we haven't talked about that, is just the prevailing party situation. I mean, in other words, it focused on, timeout. Portfolio Recovery has prevailed on nothing in this case. I mean, they prevailed at nothing at the trial court level, or they've only overturned the remedy of my prevailing party client.
So the only issue then is appellate attorney's fees, right? There shouldn't have been any consideration of any fees in aid of collection, either in the trial court or anywhere, because the only issue is appellate attorney's fees.
Correct, none of which was spent collecting that.
So I don't care what the amount was, because you said until it went back down and we saw, well, what applies to this and what applies to this, all the appellate fees were directed toward directed toward attorney's fees. So there's no issue that the appellate, if the only issue on appeal was attorney's fees.
Which appeal? This appeal? Or
the prior appeal.
okay.
if the only issue was the award of prevailing party fees, and there is no question that the credit card company was not the prevailing party, then the only issue, the only fees that were awarded would have been appellate attorney's fees, correct? Because that's the only proceeding they prevailed in.
The only proceeding they prevailed in was the appeal to overturn our remedy, which was our attorney's fee award, yes.
So there would be no need to go back to figure out whether these fees were incurred in connection with the collection proceedings or incurred in connection with the appeal, because the only fees that were granted were incurred in connection with the appeal.
And the appeal had nothing to do with collection, yes.
Right, okay, so once again, we are back to entitlement as opposed to amount.
I mean, I guess again, I would, ex post facto revisionist history, we can come to that conclusion. When I'm standing or we're arguing at the circuit court for the first time, and the only thing that is before us is the collection cost provision, and there's no evidence, and I don't know what the attorneys have done for PRA at that time, I can't make that argument hypothetically or surmising what they may or may not have done for their efforts on appeal. I've worked with Mr. Sickles' firm.
Just let you know, you're into your rebuttal now.
Okay, very good. So, Your Honor, I do think that all of the efforts spent by PRA's attorneys on the appeal had nothing to do with collecting the debt. And so while there may be an entitlement to fees, 0 is still a number, and you can't come to what they are entitled to until you look at the evidence to weigh whether or not they were collecting the debt or not. I will reserve.
Thank you.
May it please the court. My name is Rob Sickles with Dinsmore and Scholl here on behalf of Portfolio Recovery Associates. I think the issue has been thoroughly discussed in the questions here. What we're really talking about is the appellate court considered the issues presented with respect to entitlement and determined that Portfolio was entitled to the fees for handling the appeal. That's what they remanded. All of these issues about the scope of the provision, about whether these were collection costs, that was all presented to the appellate court, and the appellate court on rehearing entered a specific order, and that order said determine whether counsel for the appeal was a salaried employee. If they are, then determine amount. I'm sorry, if they are not, then determine the amount. If they are, then there's nothing further because the provision doesn't apply. Had the appellate court determined that this collections cost provision made sense as argued, they would have said determine what portion of those fees were spent on collection. The appellate court knew what it was sending back and sent it back after the request for rehearing. If you look at the provision, which was discussed earlier, it states, as noted, to the extent permitted by law, you are liable to us for our collections costs if we refer a collection of your account to a lawyer who is not our salaried employee. These costs include reasonable attorney's fees. There's another section. They may also include cost and expenses of any legal action. So it goes beyond just collection. It says any legal action. And what we had here was a collection action filed by a third-party law firm, Hanna and Associates. It's in the record, statement of claims filed by Hanna and Associates. If we need to go back to the trial court and assess whether Hanna and Associates is not a salaried employee, we can do that. That's not an issue. The collection action was filed. At that point, Mr. Wood retained counsel and raised issues. Those issues were litigated in the collection action. And what happened was the case was ultimately dismissed for lack of prosecution because the collections firm did not move it forward fast enough under the small claims rules. So there wasn't a prevailing party situation in the sense of Mr. Wood was vindicated and determined not to owe money. The clock was run out. So,
Well, I mean, come on, the case was dismissed in his favor, right? I mean.
for lack of prosecution,
Yeah.
it wouldn't bar litigation.
Would bar future stuff,
Yes.
I get it, but.
The case was dismissed in his favor, absolutely.
Yeah.
So at that point, Mr. Wood made an affirmative election to seek his attorney's fees, and he was awarded those attorney's fees. The appellate court deemed that that award was improper because the wrong law was applied, and we are where we are. After assessing that issue, the court said this is a collateral issue with respect to attorney's fees. They prevailed, being PRA prevailed on those attorney's fees issues. And once that happened, the fee provision was triggered because it arises out of a collection action.
What if the referral was totally frivolous? And Mr. Wood had moved for fees under 571051. And You challenged that on appeal, and on appeal, the circuit court had said, yeah, we really can't say for sure whether at the time it was brought, they knew that it, it just said, no, you're not entitled to your fees under 57-105-1.
Right.
You would still be entitled to attorney's fees.
I think that the appellate court could award attorney's fees under this provision if it elected to do so and under South Dakota law. I mean, that's what we were traveling. Whether 57-105 applied at all should have been, not an issue because the choice of law provision in the contract was clear. South Dakota law governed the relationship between the parties. So if the court had awarded fees as a sanction, again, that's the appellate court's determination when a fee motion is before it, whether fees should be awarded. And they made that determination. That's an entitlement issue.
And are we bound by the circuit court's initial decision on entitlement?
That's a very difficult question that I looked at extensively for today because at the time, the circuit appellate court was the next step appellate court, then the legislation
Now they're
changed.
gone.
Right, now they're gone, they no longer have appellate authority. So, I mean, had the district court of appeal, had you guys awarded fees, I think it would be binding because it's already been determined by a panel. You don't revisit that, the Supreme Court would.
That's still a non-final order.
Once the amount's determined, I believe it becomes a final order subject to appeal.
But it would be a non-final determination on our part that it was, entitlement would be a non-final determination on our part. So you're saying after it goes to the trial court for determination of amount, we are now bound by our prior non-final determination?
Yes,
We can't review orders
Right.
that only determine entitlement.
Right, no, until the amount's determined, it's not a final order.
But a court can generally reconsider its non-final order.
Yes, that's true. And so, I mean, I guess,
I don't know the answer.
I don't-
I couldn't find that.
and I was looking at it more along the lines of the second DCA reviewing a circuit court, you would always be able to reverse a circuit court under most circumstances. But here, because they were at the same level, I was looking at it more along those lines because I don't think it's been claimed that entitlement, should be reviewed at this point. But I mean, the court, I believe you could if it's a non-final order and it hasn't been determined. I mean, I haven't seen anything in attorney's fees for appeals that would say that. But I know courts can reverse their own non-final orders at various times, although, arguably under the law of the case doctrine, now it's an appellate court decision, so I guess the circuit court could review it. I just don't know. I don't know the clear answer to that, especially in light of the change in circumstances.
Can I pull you back
Sure.
to your reading on the collection costs paragraph?
Yes.
Has me still scratching my head a little bit, and here's why. So you have a subsection title, collection costs. You have a sentence, except for law, you are liable to us for our legal costs, subject to if we refer collection of your account to a lawyer who's not a salaried employee. So that preposition, if, seems to be what the hook has to be in order for entitlement to attorney's fees. These costs include reasonable attorney's fees, great. They may also include costs and expenses of any legal action. You're reading that pretty expansively to mean, okay, well, that's a standalone sentence that means, look, any kind of legal action that comes, including this appeal, could subject you to a one-way attorney's fees provision. Why wouldn't we use that they, which is bugs me that that's how it's worded, but it is, they refers to the legal costs previously referred to in the two prior sentences, both of which were contingent upon it being a collection.
No, I agree with you that the they refers to legal costs. Legal costs is then determined to include attorney's fees
Which
for
is,
somebody that is not a salaried employee.
right,
And then you could read that again as these costs include reasonable attorney's fees. So they're saying the term costs includes reasonable attorney's fees.
yeah,
And they, meaning these costs, may also include costs and expenses of any legal action.
yeah,
Now,
except you went back a little ways, but you stopped before you got to the part where I'm looking at, which is the they here is necessarily and inextricably, I mean, it's all part of the same paragraph, all under the
Right.
same subheading of collection costs. That they refers back to legal costs if we refer collection of your account to a lawyer.
Right.
Collection of your account remains. the
I don't
only
dispute
provision.
that, Your Honor.
Okay.
I mean, I think once collection of the account is referred,
That's the hook for everything.
right, then attorney's fees are triggered. If in-house counsel is collecting this, there's no attorney's fees. But if it's somebody who's not a salaried employee of the company that is doing the collection, then attorney's fees are available at that point. That's what triggers the clause.
And you're
And-
saying it doesn't make any difference in this case if it were dismissed, if the action is dismissed?
No, Your Honor, because at that point, we are
Because
not
it's all the
asking for
same
fees for
proceeding.
prevailing on the collection action. We're asking for prevailing fees on the improper remedy obtained by plaintiff, by the defendant,
But that's not
which is the
collection.
attorney's fees.
But I mean, you can see that is not a matter referred to collection.
Well, it was, they
It
obtained.
was, but now you're looking for something else. You're looking for relief from an improperly obtained remedy.
If the plaintiff had brought a counter, I'm sorry, if the defendant had brought a counterclaim.
That we can't ignore ultimately resulted in a collection of zero.
Correct, absolutely. It did result in a collection of zero. But Mr. Wood obtained relief in that collection action that he's not entitled to.
Yeah.
So as part of that collection action, that was then.
So maybe the response is kind of write a different collection cost provision.
That's possible. That's certainly possible. We have the collection provision that we have here.
Yeah.
And, it's been assessed as an entitlement to the appellate fees for setting aside,
Did anyone argue below this was ambiguous? I love asking this question because did anyone ever argue this was ambiguous below?
Well,
At
no,
any point, either circuit court or the county court, or did both sides do it is clear and unambiguous and I win?
they did. And in fact, Mr. Wood asked for fees for the appeal as well, which was not a collection action. If his position is it wasn't a collection action, then he should never have asked for fees. And I know 57105, the idea that it just relates to the contract, what 57105 is supposed to do is make a mirror image of whatever the attorney fee provision is. So if Mr. Wood can obtain fees for this action and for the appeal relating to his fees, then the mirror image of that fee provision would be that my client obtains those.
So you're
fees. Now,
saying they conceded that by filing their motion for fees under this section, that they conceded the issue that these are collection costs?
yes, they would have had to have been. Otherwise, they
They
can't
wouldn't have
obtain
filed
these
their
fees.
motion.
Yes, I mean, otherwise, they aren't, I think what they conceded is it's part of the same collection action, which is the position that I think both sides have taken throughout the whole thing. I don't think they would be saying they're collection costs. I think what they would be saying is they're part of a collection action. In that collection action, fees can be awarded under this provision. So the fact that fees were sought and not granted by the circuit court in its appellate capacity by Mr. Wood establishes clearly they were governing and traveling under this same paragraph to try to get fees for the same work. So, it's a little problematic to then come later and say, well, that provision should never have applied. That's not what the appellate court ruled. The appellate court ruled it should be a one-way provision because South Dakota law applies and South Dakota doesn't have a 57105 statute to reverse those provisions.
Did they file that same motion for the appellate fees? Or just the underlying trial court?
The same motion for the appellate fees in the circuit court appeal.
Yes, in the appeal.
Yes.
Would did.
Yes, not in this case. Nobody's sought fees in this case. But in the prior case below, fees were sought. I did want to mention the standard review. I know our briefs have differing issues on that. South Dakota law reviews attorney's fees awards under abuse of discretion standard. We've cited multiple cases in our brief that that's the way that it's reviewed. And South Dakota law governs this case because the order of the circuit appellate court finding that hasn't been challenged. So we are traveling under South Dakota law. In the reply brief, there's a case cited. It's the Hoffman versus Olson case. And they say that under South Dakota law that they consider legal issues as a de novo standard. It's just simply not what that case holds. I just wanted to call the court's attention. If you look at what the appellate court from South Dakota says is issue 1, it's on page 5 of the decision. It says whether the trial court abused its discretion in denying fees. So even the only South Dakota case that they cite that says it somehow changes the standard of review from abuse of discretion to de novo, the court in that case is reviewing that attorney's fees award under an abuse of discretion standard. And if you apply that standard, I just don't think anybody could say that reasonable minds can come to no conclusion that would allow for an award of attorney's fees under that provision, especially in light of the fact that the appellate court considered all the issues. They considered a rehearing and gave very specific instructions on remand as to what should be examined. So I think at that point, they assessed the issues and determined, in their view, what the proper remedy
Can I
is.
just run with you with that for just
Yes.
one quick question? How would one review the interpretation of contractual text under an abuse of discretion? So I'm just so used to doing that de novo. Would it be something along the lines of, that's not an unreasonable construction of it?
Yes, I think
Okay.
that's what the abuse of discretion standard would apply to that. And I agree, it's a very odd circumstance. It's just, traveling under South Dakota law, there are no cases that I could find, and I imagine the counsel for Mr. Wood could not find either, that held or discussed the de novo standard of review fees. And that may be because procedurally, fees have to be requested in South Dakota for an appeal at the time that the appeal is filed, and in most cases, they are granted one way or another. South Dakota seems to always grant appellate fees one way or another. With that being said, I want to speak to the issue of not filing an affidavit or anything with our motion for fees. We at the trial court said South Dakota law governed this. We lost. So we were traveling under Florida law, Florida procedure at the time. We were in a Florida court on Florida appellate procedure. We followed the Florida appellate procedure for filing a motion for fees. The court, because you have to file it at the time we filed our reply brief, so we're still in Florida. The court says, no, South Dakota law governs. And then it's like, whoop, gotcha. South Dakota law requires you to file affidavits. Well, our position was, yeah, sure, South Dakota law, but we lost. So we followed the procedure that was in Florida's rules and procedure for filing our motion for fees and attaching affidavits and fee receipts, things like that are not part of that here. I agree, had this has been the opposite and had the court ruled that South Dakota law applied below, and that was our position, and we were enforcing that provision, then I think maybe we would have had to have complied with South Dakota's laws, although I still get back to it's procedural. I mean, the rules of procedure for Florida appeals discuss how you file an attorney's fees motion. So I don't even know that if South Dakota law governed, that procedure would necessarily apply, because obviously in choice of law situations, it's substantive goes to the state where the choice of law is, but procedure goes where the forum of the case is. So, in wrapping this up, at the end of the day, Portfolio undeniably filed a collection action in this case. They had referred it to a third-party attorney. At the conclusion of that case, fees were improperly awarded. That issue was appealed. It is all arising out of the same case. The attorney's fees were awarded by the same county judge, same county court that issued the dismissal. She determined the amount as instructed by the appellate court, and under an abuse of discretion standard, we think the fee order should stand. Even under a de novo standard, we would believe that the fee order should stand. Thank you.
Thank you, Robert.
Yeah, 4 minutes.
Thank you. So a couple things, I guess just to go back and reiterate and or clarify Your Honor's question. I do believe first and foremost that you can follow the circuit court's entitlement order and still find the trial court's order with reversible error, because again, they can be entitled once the evidence was considered. None of the time was compensable because it was not collection costs, not within the scope. And so therefore, once the evidence was looked at, $0 is awarded, the entitlement order stands, and the amount of the quantum is reduced to 0 based upon the evidence once presented. As far as whether or not the entitlement order, could be challenged, I mean, it's interesting on the order of motion for rehearing, the circuit court judge cited for the first time Stockman. Okay, they basically, I believe in an incorrect way, cited Stockman for the proposition that attorney's fees and costs are independent and collateral wholesale, almost completely divorced, if you will, from the underlying issue. That's just not the Stockman case. I mean, the Stockman case really stands for a pleading. One must put the other side on notice that they're seeking attorney's fees and costs. And in fact, the Florida Supreme Court overturned the lower court's tribunal, which focused on the fact that attorney's fees are because they're collateral and independent, that it's okay for them to be brought up for the first time after the underlying case is over. That's what was reversed. Stockman stands for the proposition that the attorney's fee issue and who is the prevailing party and the merits of the underlying case are not divorced, but are still together. It's just the evidence that would be needed to be considered for the attorney's fees, what was focused on, were they the prevailing party, et cetera, is first and going to be seen after the underlying case is over. I do believe, we've talked about, some of the, what seems to be perhaps absurd results of someone prevailing wholesale in a case, having fees awarded and a multiplier, and then that remedy is overturned and all of a sudden, they owe money when they didn't owe anything down below. I do think that under the Juliano case, that's Florida Supreme Court case that talks about even if the entitlement order were to stand, I do think that this court has the ability under the manifest injustice standard to revisit that entitlement order and consider its merits, both under whether or not you're considering did PRA prevail or whether or not the amount was capable of being reviewed by the trial court below. PRA also importantly, when we're talking about scope, PRA in 2017, when Mr. Wood first prevailed on this case, PRA took the position that the scope of this collection costs provision mattered, and because Wood wasn't collecting the debt, Wood again wasn't entitled to fees. We talked about 57-105 being the statutory enlargement, but it's just curious that PRA focuses at the trial court level below on the propriety of the scope of the collection cost provision, but now on appeal, it's just if it's referred to anyone regardless of what the efforts are and regardless of the result of the case. So for those reasons, Your Honor, we do think that there is a basis for reversible error here. We would ask that the trial court's order of awarding fees to portfolio recovery be reversed. It's $0 judgment entering in our favor.
Thank you all. All right, at this time, we're going to take a short 10-minute recess and do a slight panel switch. So